Hi, I'm Mark, and today I want to talk about some cuts in workers' rights that are possible now because of Brexit. The UK is no longer bound by EU rules, and a consultation paper indicates how the newly won freedom is to be used in the area of labour law. Today's UK working time regulations, the Work Time Regulations 98, are largely based on European law. As a British feature, there's only an opt-out. That means the possibility for the contracting parties to voluntarily waive the observance of the maximum working time of 48 hours per week. The government wants to keep the most relevant regulations, in particular the rules on maximum working hours, minimum breaks, and minimum holidays. There should be no dismantling of employee rights or even social dumping, is what they say. However, bureaucracy in the form of record-keeping obligations is to be reduced. They call it bureaucracy. We come to that later. This topic is made particularly relevant by the judgment of the ECJ on the recording of working hours of May 14th in 2019, in which a comprehensive recording of working hours is required. On the other hand, the British government is proposing to generally abolish the obligation to keep records of daily working hours. And they say it's to reduce unnecessary bureaucracy. And this measure is also expected by them to promote trusting cooperation between employers and employees. The working time regulations are derived from the European Working Time Directive and create various entitlements for workers, including minimum rest breaks and maximum working hours, as well as an entitlement to paid annual leave. The Working Time Directive was intended to protect workers' health and safety by regulating working hours, rest periods, and this entitlement to paid annual leave. British law grants all employees a right of 5.6 weeks of holiday per year, which corresponds to 28 days calculated over a 5-day week. 4 weeks of this is the statutory minimum leave, and this entitlement results from European law. The other 1.6 weeks, however, are not required by European law. They result from a decision by the British legislator. There are two holiday types that differ with regard to the calculation of the remuneration to be paid during the holiday. In addition, only the additional holiday entitlement can be carried over to the following year. The British government plans to create a uniform holiday entitlement of 5.6 weeks per year. The remuneration to be paid during vacation will also be uniform, although there are no plans for calculating this yet. The consultation is intended to collect suggestions for this. What should remain unchanged, however, is that only 1.6 weeks of vacation may be carried over to the following year. Another proposed change relates to a practice that was originally widespread in Great Britain, but which the ECJ has declared to be incompatible with European law. The inclusion of annual holiday pay in the regular salary, so the called rolled-up holiday pay. In contrast, European law requires the separate calculation of remuneration for the holiday period, the basis for calculation being the average salary within a specific reference period before the holiday. The British government proposes that rolled-up holiday pay should be possible again. And the government is planning changes to the consultation requirements in the so-called TUBE regulations to simplify the transfer process while ensuring that workers' rights continue to be protected. At least they say that. The transfer of undertakings with the Protection of Employment Regulation 2006, the so-called TUBE, implement the EU Acquired Rights Directive. The purpose of the TUBE regulations is to protect employees' employment rights when the business or undertaking for which they work transfers to a new employer. TUBE may also apply when a business changes owner or when a service transfers to a new provider, for example, when another company takes over a cleaning contract. Where TUBE applies, employees' employment and associated rights legally transfer from their previous employer to their new one. Some changes to terms of employment are allowed under specific circumstances, for example, where there is an economic, technical, or organizational reason for the variation. When it comes to transfer of business, the United Kingdom knows the Transfer of Undertakings Protection of Employment Regulations 2006. These are also based on European law, and the standard of protection should not be worsened here either, they say. However, they claim there would be some relief for employers when it comes to consultations with employees. So far, these may only be conducted with elected representatives and not directly with the employees. There's only one exception for companies with fewer than 10 employees. And according to the government's proposal, companies with up to 50 employees should be able to benefit from this exception in the future. So more employees are affected by this. The consultation on recording working hours, holiday pay and transfer of business is currently open, and people can still participate until July 7th in 2023 on this consultation. The post-contractual non-competition clause is another point. It's not about remnants of European law, but about English common law. The UK government addressed this issue in a separate and already closed consultation in 2020. A post-contractual non-competition clause is an agreement between the parties to an employment contract. It states that in the event of termination by the employee, an activity that competes with the previous employer should be prohibited for a certain period of time. Unlike here in Germany, no mandatory waiting allowance is payable in such a case under English law. The effectiveness of such a ban can only be determined on a case-by-case basis. The decisive factor is whether it adequately takes into account the interests of employers and employees. And this is always accompanied by a certain degree of legal uncertainty. In future, post-contractual non-competition clauses can only be effectively agreed for a maximum period of 3 months. In this way, one wants to stimulate competition, promote the creation of new jobs, and enable innovations, they say. However, the important question of whether this regulation only applies to the future or whether bans agreed in the past are also covered has not yet been answered. What is certain, however, is that the requirement of reasonableness must also be taken into account if the ban is only to apply for up to 3 months. There is therefore no guarantee that a non-competition clause will be effective in the future either. And as I already mentioned, they are planning some changes on the tube regulations. And this really affects the side of the workers. With all the things I mentioned already, that is, I went through the whole consultation paper, and they are asking a lot of questions now, but the direction they want to go is quite visible there in this paper. And it all goes on the rights of the employees. And they always claim it's to get rid of bureaucracy. But this, what they call bureaucracy, including the working hours that need to be there in proof on black and white, so to speak, are for the protection of the employees. And all this is on their list of being scrapped. So I put the title on this video for a reason. Because some changes to terms of employment are already allowed under specific circumstances. But they want to widen those exceptions by far. And that's why I put the title the way it is. Because those plans are going to cut rights and some safeguards from the employees, always claiming it's to make it easier for the employers so that in the end they will hire more people. There's a staff shortage in the UK. So this cannot be the reason for all of this to make employers hire more people. They can't even fill the gaps they have at the moment. So looking at this consultation paper, there, for me, are clear signs that they are going for reducing workers' rights. We will see how the decision will be in the end, but the consultation gives you quite a clue of what they're planning. And I also want to say a few words about the banner you see since yesterday. And I talked about this in the video yesterday about the plans for a new channel, but it needs a bit investment. And so that's why the banner is up there in case somebody wants to support this channel to be able to do this on the new channel. And I want to thank a few people that already contributed to this project. And I want to really say a big thank you. As I said yesterday in my video, it doesn't matter how big the contribution is. Every small contribution helps to achieve the goal of this project, to get the channel started. And so I really appreciate everyone who already contributed to this. We are not close to the threshold yet, but still, I appreciate every little bit, and I'm really thankful to every viewer who wants to help create this new channel. It cannot be properly done in a channel in a very competed zone like this. I need to start with something trending. That means something of the new things that just got out, and I have to invest there a bit. And with advertising after the crisis and so on here on YouTube, I have to be careful with my investments at the moment. I still have costs of living myself, and so it's not possible to do everything I would like to do on my own. But with the help of some of my viewers that are already contributing to this project, it is possible. And so I really want to thank you today. It started yesterday, and the first, no matter how small, once again, no matter how small contributions came in. And so you are helping opening a new Outside Views project, and I really appreciate this and just want to say thank you. And for everyone, I'll see you in my next video. I'll be back.